I want to take it, and just if they call me, you just answer that I'm here.
Okay.
Okay, today being the day we have set for the preliminary examination, it is a little examination. It is currently 9:27, this matter was set for 9 a.m. examination. And not hearing any reason that would explain why Ms. Lindsay is not present here today.
Okay. Calling parties on John Dawson. Calling case number 1562740, People versus John Wesley Dawson. Defendant is charged with count 1, malicious destruction of personal property, utility property. Defendant is a habitual offender. Third offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good afternoon, Your Honor. Jacob Slutsky on behalf of the people, P83677.
Yes, good afternoon, Your Honor. May it please the court, Delphia Burton appearing on behalf of Mr. Dawson. Mr. Dawson is in federal prison. I do apologize to the court in terms of not getting back sooner. I was checked in this morning, but.
That's okay. So what is, are you requesting to waive his presence or?
Well, Judge, we have an issue. The court wanted to find out how to make contact with Mr. Dawson. It has to be set up through, through the court. So I have the information. I could put it in the chat for your clerk in terms of, his location and his inmate number. Well, you said you wanted him to be able to participate.
Oh, yes, I don't process the writs though. The prosecutor would need that information. We don't process the writs. So Mr. Lusky, can you make note of what she's about to?
Of course. My understanding was that today we were going to ask Mr. Dawson if he consented to hold the exam on Zoom. Based on the information communicated from the defense, I understand that he is in federal custody in Arizona, but I was not able to locate where he actually is or any information about him. The federal
because you were probably looking at, he's not a prisoner. He's in a detention facility. He's at Central Arizona Florence Correctional Complex. But I can give you the information.
Can you email it to me?
Or you give me your number and I'll call you on it later.
I'll send you my email in the chat. Please email it to me.
Okay, sounds good. We can do it that way. So can we get another target date, Judge?
Yeah, well, how much time? Well, let's assume that we'll need probably maybe at least 10 days to effectuate a Zoom writ. I don't know. We're just I'm gonna give a date. If you find out that's a problem, then you can circle back and let us know. Today's the 23rd. We'll say, let's reconvene on August 6th.
Your Honor, I'll be unavailable for the first 2 weeks of August. We could do either next week or after either the 16th.
July 30th. We'll see you on July 30th.
Okay.
July
30th. Give him enough time.
You pick a day.
If it's a Zoom writ, there's not always the 10-day requirement, which now I've just recently found out has been changed to a 14-day requirement.
Pick a date. Pick a date.
Yes.
Or I can. Let's do it this way. August 16th.
Yes.
August 16th at 8:30 via Zoom, and that should be more than enough time.
Okay, thank you.
Thank you so much.
Right. Okay, thank you, Your Honor. Thank you, Mr. President.
Okay, can you call the next matter?
Calling parties on Gregory Kaisen. Calling case number 2057004, People versus Gregory Lewis Kaisen. Defendant is charged with 1 count, stolen property, receiving and concealing $20,000 or more. Defendant is scheduled today for a motion hearing.
Appearances, please.
Good afternoon, Your Honor. Jacob Slutsky on behalf of the people, P83677.
Good afternoon, Your Honor. Good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Kaisen. I believe he is in the waiting room. I spoke with him a little earlier. I know the court didn't necessarily or at this hearing, based upon our conversations the last time, but I believe he is present.
Can you restate everything you said? Your audio sounded very warped.
Mine,
I do see him though. You don't need to address that part, but Madam Court Reporter, did you want him to repeat?
You know what, he was warped, like you said, I couldn't.
Yeah, just if you could put your appearance on again, understanding that we do see your client. You don't need to repeat that information. But please
Okay.
put your appearance on again. Your audio was warped and we could not really hear you.
okay. Good afternoon again, Your Honor. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Kiesgen. If the court would allow me, I'm in another courthouse. I'm using a signal from my hotspot. I believe they have a public signal here, which is much stronger. Can I take a couple of seconds to see if I can get the password to the courthouse? And, okay, give me 1 second, yeah.
Mr. Perkins, are you good to go?
I am.
Okay, if we could address one scheduling matter.
Wait, I don't mean to interrupt, but Mr. Perkins, thank you for your appearance. Can you have your client put his name on the record?
Yes. Mr. Keesgan, can you announce yourself, please? You got to put your take it off on mute.
Gregory Kaisen.
Thank you.
Thank you.
Mr. Schlesinger.
Okay, so Your Honor, about a month and a half ago, roughly speaking, I was informed by Lieutenant Schwedler that my complaining witnesses would be unavailable at the scheduled exam, which I believe is coming up next week, if I recall correctly. I notified the court of that at that time. Including Mr. Perkins, I notified him as well. I got a response from him last week stating that he would not object or that he would stipulate to adjourning that. I was hoping that we could just get the scheduling out of the way and have a date picked that they would be available, that Mr. Perkins and myself, and of course, Mr. Keesgan is available as well.
Okay, so unfortunately, as you know, this is not an in-custody matter, so the date will not be right around the corner. I'm assuming that, Mr. Perkins, you've talked to your client about that. I only say that because most people are shocked for some reason and think that perhaps the court system has not been affected by the pandemic, much to the contrary. So we really don't have a whole lot of availability through December. But because this is a reschedule, I'm gonna ask Mr. Clerk to find a date in late October, which is really reserved for assaultive, non-custodial matters. But given that this is a reschedule, I'm going to ask him to find a date then.
Yes, I did speak with Mr. Keesgan, Your Honor. We, Brother Consul had brought that up some time ago, and we did come to, we do agree to, I mean, it's a long-standing matter. It's another 60 days. It's another 60 days.
How about October 29th at 10 o'clock?
October 29th at 10 a.m.
I just set a trial date, Your Honor, in Macomb for that date. It's a Friday. If I could have, I know you're trying, but I can't accommodate that date.
How about the 28th at 10:30?
October 20, 10:30?
Just one moment, Your Honor. Yes, that is a good date for myself. If just one moment, Mr. Keesgan, is that a good date for you?
Yes, it is.
Okay, thank you, Your Honor. Yeah, that's a good date for me.
Okay, the in-person examination is going to be October 28th
8 at 10:30.
at 10:30. Okay, as to the motion. as to the motion? Was there a motion?
Yes, there was, I believe, 2 motions. Wait, hold on just a moment, Your Honor.
Okay, so just so everybody's aware, when there's a motion scheduled, my expectation is that the moving party is going to present their motion, and then the responding party is going to respond, even if there's been a writing. So please don't rely upon what you've submitted. This is the time for you to present what you've got.
Yes. Okay. Did you want us to do them one at a time, Your Honor?
Whichever, honestly, I'm fine. I'm
Okay.
whatever you would feel most comfortable doing, I'm here
Okay.
for.
All right. So I'll start in the succession in which I've received responses from Mr. Slusky in this matter. The motion for discovery in this matter is, pardon? I didn't know if did you say something, Your Honor?
Oh, me, no.
Oh, okay.
I didn't say.
All right. So the motion for
Reading my thoughts.
okay. All right. So, okay. May it please the court. The first motion that I'm bringing up is a motion for discovery. It's clear that the prosecution's position is they've tendered discovery, but yet it's clear that there's certain things. And what I'm going to essentially ask, since they have indicated that they've produced all the discovery, there has to be an evidentiary hearing as it relates to this to show and demonstrate that there is a host of discovery that has yet to be produced. So we have one, we have.
You go any further. I see that there are a number of people here. I'm not sure if they're waiting on another case or if they're here for this case. Does anyone know?
I have Lieutenant Schwedler is the officer in charge of this case.
And? I've never met Lieutenant Schwedler. Is he here?
He is. He's in the gallery.
Are you here, sir?
Good afternoon, Your Honor. Andrew Schwedler.
Oh. Good afternoon. Pleasure to meet you. So there's a couple of other people, and I'm not certain, Mr. Clerk, if you've had any contact with them, but there's someone with Mary's iPhone and
I was trying to get that person's attention.
Mary Wright, Bill Pyatt, I don't know. So if you can hear me, these individuals, if you have a question for the court, please take down this number and call Mr. Clerk. 313-965-2282. Mr. Perkins.
Yes. Well, in light of that, thank you for that, Your Honor. I would motion to sequester any and all witnesses. I understand the court's limitation in this matter. There's being a request for an officer in charge to be present. I'll let the court make that determination if it's so requested by the prosecution. But I would like some limiting instruction to anyone on YouTube or who may be present in the gallery or on these pictures alongside in the Zoom room, that they not be present at this particular time.
Okay, so the only people that are here that are people that are involved with this case. The court is here, Madam Court Reporter is here, your client, yourself, Mr. Slusky, and I'm assuming, is it Detective Schwedler? Is the officer in charge. And the other one are just courtroom Zoom cameras. So if there's anyone watching, well, let me just ask, Mr. Slusky, were you asking for an exception for your officer in charge?
Yes, Your Honor. At the last hearing, you requested that I ask my officer in charge to be here. And so.
Oh, well, yes, I would imagine because you would want him here because there were so many open-ended questions you couldn't answer. That's why I asked for him to be here, because we can't keep going back and forth saying, well, I asked, but I don't know what's going on. So yes, thank you for being here, officer in charge. Is there an objection to him being present? Because Mr. Perkins, at the end of the day, if Mr. Slusky can't answer your questions, that's why he's here, the officer in charge.
And to not necessarily to short circuit it, that's why I think it's necessary to have an evidentiary hearing, because there are so many unanswered questions, even from the prosecution, who is essentially the agent for the people on this really typically succinct issue as discovery, because there are so many different things that have happened in this case that and look at the charge. It's innocuous enough. It's receiving and concealing stolen property over $20,000, but there's so much more into this. There's apparently some widespread investigation, really, of other people in which Mr. Kaisen is ensnared in this process, but yet because I have yet to receive any records of helicopter information at his house, the information as it relates to, I just received the search warrants to a couple of his properties. I think two or maybe four search warrants. I've received those the last time, right before the last, or sometime before the last court date. But again, there are no records. There's no activity logs that I asked for that have been requested. And in fact, early on, or very early on, I had, before Mr. Slusky became involved in this case, I approached Dennis Doherty to get an agreed upon discovery order. And there was really the request that I'm making now, there was really no objection to that particular information that I'm asking, because there's a search warrant in Rochester Hills. There's two of them. Then there's apparently a search warrant in Roseville. So, the activity logs and the officers who were involved, far number. I mean, we're talking about anywhere from 30 upwards of 30 officers who were involved in this particular investigation. And so I don't have any of those activity logs. I think it's, given the expansiveness of this particular investigation, it merits producing that information. And I know sometimes people say, well, that's not relevant here, but what the prosecution deems to be relevant does not mean that that's an issue for discovery. That may be an issue as it relates to why those questions may not be asked at some testimonial aspect of this particular case. So again, as I've mentioned in our motion, prosecution feels like it's produced all the discovery. If you look at my motion and what we're asking for, those are clearly discoverable items. And whether, the prosecution has indicated that there's a lot of investigation that's going on. Clearly, they have some understanding beyond my limited knowledge, a little bit more knowledge since Mr. Slusky has turned over some additional discovery. But again, what I'm asking for is not onerous. It just should be produced. And so that's what we're asking for as it relates to that. But I do believe that there should be some evidentiary hearing as it relates to discovery. I mean, it really is that important to nail these things down and find these things out even before we get to the examination portion. Thank you.
Your Honor, okay, so I've made a list of 5 things to respond to. First, I would disagree with the characterization that there's a number of unanswered questions here, particularly because it is my understanding that this information that Mr. Perkins is requesting has already been tendered and was tendered before I received 2 out of 3 of these motions. I offered
that should be easy to shore up. Let's not gloss over that. It's either there and has been tendered and received, or it hasn't. Let's go through a checklist.
Okay. I have a list. I intend to go through it. So there's a reason I offered to go through this with Mr. Perkins. 75 pieces of evidence is a lot, and it would be easy for something to get missed when you receive that much all at once. So regarding the helicopter, I have the OIC here, and I am sure that he can answer to that. Mr. Schwedler, was a helicopter involved in this operation to your knowledge?
No, it was not.
Was there any helicopter that you saw or that you're aware of in any capacity that was involved with this investigation as far as you're aware?
No.
Okay, well, we
Okay,
have that one.
Let me stop. And so that's one aspect of it. And this is the reason why we need an evidentiary hearing, because I would call witnesses, Mr. Keesgan's neighbors, who, you know, because I don't want to put my client on the stand, but I would call his former neighbors to testify that not only was his subdivision shut down, this is an offer of proof, and to the reason why, you know, this is the reason why, as it relates to this motion, we don't need to go any further other than requesting an evidentiary hearing, because it's going to be testified to by neighbors that there not only was the subdivision shut down, but that there was a helicopter that was over above, I believe, and upon information and belief, it was a law enforcement helicopter that's hovered above while there was an execution of the search warrant at his house.
Now, you just heard that, I'm sorry, you referred to him, Mr. Slusky, as Mr. Schwedler. Is that your officer in charge?
Yeah, I apologize. I should have said Lieutenant Schwedler. That's
Lieutenant Schwedler, as the officer in charge, just indicated that there was no helicopter involved. Is there, are you, I guess let me ask you this, Mr. Schwedler, Lieutenant Schwedler, can you please state your name and spell your first and last name?
Andrew Schwedler. First is Andrew. Schwedler, Schwedler.
Thank you. Can you please raise your right hand? Do you solemnly swear or affirm information you're going to provide here today is true and accurate to the best of your ability, sir?
Yes, I do, Your Honor.
Thank you. Was there a helicopter involved in the basis for these allegations that the defendant has brought before the court for?
No.
Did you want to voir dire him, Mr. Perkins?
No, I want to present witnesses. He's clearly and succinctly said no. So therefore, it becomes a question of fact, even at this basic stage, that there's a question of fact as to the existence of discovery or not. So that's the telltale points of the necessity of an evidentiary hearing. I mean, he said no.
So I don't know, perhaps there's some other action you may be trying to forge ahead with Lieutenant Schwedler, but
I mean, I can cross-examine him if the court would allow.
Sure, yeah, yes, that's what I was asking if you wanted to work. I don't know, to set it for another hearing where he's gonna be sworn in to say the same thing.
Okay. Oh, thank you, Your Honor. May it please the court. Lieutenant Schwedler, I'm gonna ask you some questions. If you don't understand them, then let me know and I'll rephrase or I'll try to offer you a question you understand. Is that fair?
It is, sir.
All right. So you're the officer in charge of this particular investigation, is that correct?
Yes, sir.
Okay, and you are the affiant in the search warrant at two particular residents which you associate as belonging to or being occupied by Mr. Gregory Kaisen, is that correct? In Rochester Hills?
Yes, it is.
Okay, and you also executed, or you're the affiant in the search warrant for other properties in Macomb County, is that correct?
Yes.
Okay, how many properties in Macomb County?
One.
Okay, and in that particular execution of, in the execution of the search warrants in the properties in either property in Rochester Hills, were you aware that there was a helicopter that was hovering above during the course of the execution of this search warrant?
No.
Were you present at the time of the execution of the search warrant?
I was in the city of Warren at the time the search warrants were executed.
Okay, so you said you were not aware, rather than saying you weren't there, you said you weren't aware of that, is that correct?
I did not order a helicopter, and I'm not aware of a helicopter being used in this investigation.
Okay, but you'd agree, well, I was getting to the point, is the reason why you said you weren't aware is because you weren't there. Is that the reason why you can succinctly say that you were not aware? Is that fair?
Yes, that is also fair.
Okay, now you didn't order a helicopter, but you recognize that there's also that you've involved yourself or been involved with other investigators through other different counties in this particular matter. Is that correct?
Yes,
And this investigation came by way of you being asked by your captain in order to investigate this issue of this truck. Is that correct?
I'm not sure where you got, I was being ordered by my captain to investigate this truck.
I didn't say ordered. I said you were asked by your captain to investigate this issue of this truck. Is that fair?
No,
Okay, so
Was it chief?
you typically investigate stolen motor vehicles in your capacity as a cross-trained firefighter?
Mr. Perkins, your audio warped at the beginning of your statement, and if someone else said something, I'm not sure if that was Mr. Keeskin. Maybe I'm mistaken, but it's inappropriate for there to be any sort of input or commentary or correction provided, unless that was Lieutenant Schwedler. I couldn't tell who was speaking when they said chief. So please, if you would, if that was Mr. Keeskin, it is inappropriate for you to comment on what's being said here. Mr.
I
Perkins?
apologize. I was just trying to help.
Okay, just one moment here. I'm sorry. So are you, as a cross-trained firefighter, cross-trained with with police, is it typical in your capacity to investigate stolen motor vehicles?
yeah,
Your Honor, I'd object at this time, not to the nature of the question, but to ask it at this period for voir dire about the helicopter. I have some other things I'd like to address, and then perhaps if Mr. Perkins would like to ask when we're addressing that issue.
Okay,
Did you want me to respond, Your Honor?
sure.
Okay, let me respond by asking another question. You were, Lieutenant Schwedler, you were involved and had discussed this matter with other officers from other jurisdictions outside of Detroit. Is that correct?
yes, it is.
You talked to officers involved in Livingston County?
Yes,
You talked to officers involved in Rochester Hills,
Oakland County Sheriff.
Oakland County Sheriff? You talked to officers involved in the Warren Police Department?
Yes,
You talked to officers involved in Roseville Police Department?
yes,
Okay. Now, could you identify who those individuals you spoke with in Livingston, Oakland County Sheriff, and Rochester Hills? Or excuse me, and Roseville Police Department and Warren Police Department?
I can.
Okay. Are they noted in you wrote a report in this matter, did you not?
I did.
And in your report, your report does not identify the specific individuals, all of whom you spoke with those various different districts. Is that correct?
I would have to reference my report to verify if every officer that I spoke with was listed in that report.
Okay. Do you need to refresh, looking at your report, refresh your memory to that effect?
I will do that.
I'm saying, would it refresh your memory to that effect?
Yes, it would. I just stated I would need to reference my report.
Right, that's what I'm saying. I'm just going over that step so that, yeah, please review your report with the permission of the court. And when you're done, let me know and I'll ask you some other questions.
Yeah, Lieutenant Schwedler, there's certain, there's a manner in which the reports can be referenced. That's why Mr. Perkins was asking you that specific question as to whether or not it would refresh your recollection. In the event that it would, please review it. And then if you could, it's the honor system here. If you could put the report, turn it over. It's not appropriate while the remainder of your testimony for you to read from the report. But if you need to refresh your recollection and that's put on the record, you certainly can review it and then put it back down. Thank you.
Thank you, Your Honor.
And in this, I think the question on the table is, can you identify the particular officers from various jurisdictions I wouldn't have a problem with, if that's what you're doing, I wouldn't have a problem with you reading the names because it's kind of, Mr. Perkins asked for a lot of different people.
Thank you, Your Honor. That would be helpful.
You're welcome.
I do see Oakland County Sheriff. I spoke to Deputy Loudon, Louden.
Is that the only individual you spoke with in the Oakland County Sheriff's Department?
No, it is not. And if I could offer an easier way to answer this question, would that be appropriate?
Well,
Sure.
In the discovery that I supplied, I did list all the officers that I had contact with, as requested by defense.
okay. All the ones that you had contact with and that were involved in this investigation, or just the ones that you had contact with? Do you understand what I'm asking you?
I believe I do, and the list that I provided had the officers that I had contact with.
Okay.
And I can't say that I'm aware of other officers directly involved with the operations that I oversaw that were involved from other agencies.
Okay.
I can't speak to anything that Livingston County did outside of my direct interaction with them.
Okay. Now, let me ask you this. In this particular situation, did you work with anyone? You're a firefighter first and then cross-trained as a Detroit police officer, is that correct?
Yes, it is.
Okay. And in your investigation of this, as it relates to Detroit, City of Detroit personnel, were those Detroit police officers that you worked with, or were they firefighters that you worked with during the course of this investigation?
The majority were Detroit police officers.
Okay, the majority. Who were the firefighters that you worked with?
If I may reference my copies of discovery that I've provided.
Well, let me make it a little easier. So what you've provided in your discovery are the sum total of individuals that you work with as far as City of Detroit personnel?
Yes.
Okay, now, so going back to my question, so going back, you were asked, I'm sorry, and my client was trying to correct me, Your Honor, but the individual who is a complainant or related to the complainant in this particular case is or was a fire chief, is that correct?
No.
Okay, a fire captain?
No.
Okay, in what capacity was that individual working in the Detroit Fire Department?
He was a firefighter.
He was a firefighter. Okay, and that firefighter is the person who contacted you to initiate this investigation?
Yes.
Okay, so that person contacted you, and you would agree that within the scope of what you're doing as a firefighter, you're not necessarily cross-trained in stolen motor vehicles. Is that fair?
No.
Is that a fair statement, or is not a fair statement?
No, it is not a fair statement.
Okay, so you are cross-trained. You're cross-trained as a police officer through arson, is that correct?
I am
Okay.
a MCOLS police officer, yes.
Understood. And you get your MCOs because that's the purpose of being cross-trained, for the purpose of the salient purpose of performing arson investigations. Is that correct?
That is the main purpose of my job, yes.
Okay. But when a friend asks you, who's a firefighter, to investigate something, you have the ability to do that too, then. Is that fair? Is what you're saying?
I wouldn't agree with the way that the question was posed, but I will answer yes if there is a law enforcement matter that happens within the city of Detroit and I am contacted by someone that I know. If it's within my scope, I do have the ability to investigate that, yes.
Okay, you had a work and or personal relationship with this firefighter before the initiation of this investigation, didn't you?
I've worked with him on the Detroit Fire Department, yes.
Okay, by your response, that it suggests that you do not have a personal relationship with them. Is that fair?
I would consider him a friend, yes.
Okay, so why would you answer the question? Nothing. So I withdraw that. So now, when you go and did you exchange in the course of being contacted? Were you contacted orally or were you contacted via telephone?
Telephone.
Okay, and did you exchange text messages as it relates to information that was that you used to initiate this investigation with that firefighter?
I don't believe so.
Did you exchange emails with any? Let me ask you: did you exchange any text messages with any other law enforcement officer during the course of this investigation, as it relates to this investigation?
Probably.
Okay, and when you exchanged text messages during the course of this investigation, did you use your personal phone or your department issue phone? Well, let me ask you this: do you have a department issue phone?
I do.
Okay, did you use that phone to exchange text messages, or your personal phone, or both?
It could be either.
Okay, all right, so upon request from this court or order from this court, you can provide that number and provide your service provider for those phones, is that correct?
I could provide the number and the service provider, yeah.
Okay, did you also, during the course of this investigation, did you exchange emails with other law enforcement officers during the course of this investigation?
Yes, I did.
Okay, and have you provided all those emails during the course of this, of what's involved in this particular investigation?
No, I did not.
Okay, and if so ordered by this court to provide those emails, you can do so, is that correct?
Certainly.
Okay, and did you use your personal email or your company email or government email for the purposes of discussing or exchanging information as it relates to this investigation?
That would only be my city provided email.
Okay. During the course of this investigation, at some point in time, hold on just a moment. Did you have any sources of information that you used during the course of this investigation?
Could you elaborate on that?
Did you executed, you were the affiant in the search warrants, is that correct?
Yeah.
Okay, did you have any sources of information for the purposes of either the affidavit in the search warrants or throughout any course of this investigation?
Certainly, I had, yes.
Okay, and when I say source of information, I'm talking, you understand that I'm speaking about individuals who provided information as being the source, is that fair?
Yes, that would be fair.
Let me ask you, beyond the sources of information, did you have any confidential sources of information that you engaged in the course of this?
No.
Okay, so when I say any sources of information, all those are the individuals that would be listed in your information that you provided during the course of the discovery?
Yeah.
Okay. Now, understanding that this is an investigation about a stolen motor vehicle, you executed 3 search warrants for the purposes of locating and identifying this stolen motor vehicle. Is that correct?
No, it's not.
Okay, what was the purpose of executing those search warrants?
Two search warrants were executed. 4 were submitted and approved.
Okay, what were the 2 that, well, let me ask you, what was the purposes of the 4 different search warrants?
To locate the stolen vehicle, the title and keys.
Pardon?
To locate and recover the stolen vehicle, the title, and the keys.
And the keys, okay. And that was the purpose for all 4 search warrants?
Correct.
Okay, and you executed 2 search warrants, is that correct?
Yes.
Okay, and in the 2 search warrants, you were able to identify, locate the vehicle at a factory on one of those search warrants, is that correct?
No.
You didn't? You located it at a commercial building, is that correct?
Yes, but the vehicle was not located at either of the 2 search warrants that were executed.
Okay, and when you went into, you recognize you went into the, so you went into another location and found the vehicle?
That's correct.
Okay, and you didn't have a search warrant to get that vehicle out of that particular vehicle, out of that particular building?
That's correct.
Okay, and you went into that vehicle, you had permission to go into that building?
That's correct.
Oh, and who granted you permission to do that?
Mr. Keesgan.
Okay, so during the course of him granting you that, you said that he granted you that permission while he was under arrest?
He was not under arrest, he was detained.
Okay, so you have a difference between he wasn't free to go at the time he gave you that information, is that correct?
That's correct. He was
And
detained.
at the time he gave you that information, he had not been Mirandized at that point either, had he not?
No, he had not.
Okay, and yet you still sought information and you questioned, you offered a question, asked for information during the course of him being detained, is that correct?
Detective Theophilus Williams spoke with Mr. Keesgan and asked him if he would like to cooperate with the investigation, and he agreed to.
Okay, but at the time, you would agree when that question and answer was going on and requests being made of Mr. Keesgan, he had not been provided his Miranda rights. Is that fair?
That is, yes, he was not under arrest.
All right. So, well, let me take a little segue, Your Honor. I would at this time motion for any suppression of any of those statements and suppression of any fruits from those statements based upon a violation of his right to counsel and a violation of Miranda. So I'll leave that at the court's feet. So then, Your Honor, or excuse me, and all of those things that flow from that would be suppressed also as fruit of the poisonous tree. So I'll leave that there, Your Honor, now, if I can continue.
Sure.
Okay, so when this situation happened, you went into that residence in the Rochester Hills residence, and you had agreed that during the course of the entry into that residence, there was a substantial amount of damage that was well inflicted on that residence. Is that fair?
I was not at that location, and I would state that substantial amount of damage is very subjective.
Understood, but you would agree that doors within the interior of that residence were kicked in. Is that correct?
I'm aware of a door being damaged on the interior.
Okay, and you would agree that there was throughout that residence, there was a, for lack of a better word, I'm not so prolific sometimes with the English language, there was a tossing and turning of the items within that house in search of something. Is that correct?
I would not agree with that at all.
So there was no rustling of any papers or anything like that took place in that particular house?
Not that I saw.
Okay, so you were at that residence at some point in time after the.
No, I was not.
Okay, so how is it that you saw these things? Through pictures?
I reviewed the body camera footage from the officers that served the search warrant.
Okay. Have you turned over all the body cam footage of these officers that were involved in this?
Yes, I have.
Okay. How many body cams did you turn over?
I believe there were 2.
2?
That's correct.
So during the course of this entire investigation, there were only 2 body cams that were turned over?
At that Rochester Hills location that you mentioned, yes.
Okay. How many officers were involved in the execution of the search warrant at the Rochester Hills location?
I don't know. I'd have to reference the activity log.
Okay. Can you do that? Your Honor, can I have a 1 minute 1 minute break? I have to make a call to. I was supposed to do something for my wife, and I don't think I can be able to do that right now.
Go ahead. No problem. Just as an aside, let me state that it is not permitted that you take any photos of this court proceeding to the iPhone user. Mr. Perkins, I'm assuming you know who that individual is, and you will instruct him that there is, unless there is authorization granted.
I don't know who that is, Your Honor.
Oh, okay, he's in Mr. Keesgan's seat. So please, I heard the photo being taken, I could see the phone up to the Zoom. Please, if you would, make sure you communicate to Mr. Keesgan and his company that any reproduction or sharing of photos taken or videos taken of court proceedings is not permissible unless there is express authorization.
Okay.
Thank you.
I apologize. I'm not going to be able to give a short answer for,
Oh, wait, Lieutenant, I don't know that Mr. Perkins is back yet.
I apologize, Your Honor. Thank you.
That's okay, looks like he's still muted and on the phone. Mr. Clerk,
Yes, ma'am.
could I trouble you to look up who the attorneys are, the prosecution and defense on an exam that's scheduled for July 27th.
Thank you, Your Honor.
Hold on, at 1:30, the Moss Matthews. If I could trouble you, I remember it's McWilliams' defense counsel. If you could find out who the prosecutor is. I recall them or the prosecutor saying that there would be a need to adjourn. And I just don't know. I don't know if they were going to wait until the 27th. They could zoom in on Monday. If that is the situation, that would be better than just having that 1:30 spot sitting there and they're not going to use it. So if you could ask Mr. McWilliams as well as the corresponding, it's an exam that's held in part on homicide. So if you could see if they could zoom in either right now or a Monday morning. So we can determine a new date and to make sure, because again, if that slot is going to be open, then there may be somebody on Monday that could use it for Tuesday. Okay, back on the record. Yes, Mr. Perkins,
Yes.
proceed.
And may I please the court, may I continue, Your Honor?
Yes, sir.
Thank you. Lieutenant, you said that you produced 2 body cams from the Rochester Hills execution of that search warrant. Is that correct?
Yes, it is.
Okay, and then did you produce any other let me ask you this. There are other body cams that are officers involved in this who are wearing body cams. Is that correct?
I don't know of any. The only other police video that I'm aware of is from Warren PD. It was at the location of Mr. Keesgan's detention and then subsequent arrest.
Okay.
Read the last part,
I'm sorry, Your Honor, go ahead.
the last part of the witness's answer. Could he repeat it?
I believe I'm aware of the 2 body cameras at the Rochester location, and the only other video that I'm aware of was from the Warren Police Department scout cars at the location of Mr. Keesgan's detention and subsequent arrest.
Okay. You mentioned subsequent arrest. At the time that he was detained, he was in handcuffs, right?
He was.
Okay. Was he placed in, he was standing outside of the scout car for a couple hours, is that correct?
I don't think it was that long. No,
It was more than an hour, right?
I'd have to look at the clocks. I don't know. I don't think an hour is out of the range from what I recall.
Okay. All right. And that's the point in time while he was in those handcuffs that he gave that information to, you said Theophilus, Officer Theophilus who?
Theophilus Williams.
Okay. Now, police officers within the city of Detroit are required, pursuant to the Department of Justice standards, are required to wear body cams, are they not?
Not all, no.
Which officers are not?
Investigators and detectives are not required, no.
Okay. So the only officers that you had working with the Detroit Police Department in the performance of this particular investigation, whether it be in Oakland, Wayne, or Macomb County or Livingston, was only 2 officers who had body cams on?
Those are the 2 that I'm aware of.
Okay, but you're the officer in charge, right?
Yes and no. Sergeant Dave Sanders of the Detroit Police Department, who works within the arson unit, organized and facilitated the officers that were provided by the Detroit Police Department outside of the arson unit to assist with the search warrant.
Okay, how many people from the arson unit were used?
I'd have to go through the activity logs to give you that number.
Okay.
Less than a handful. Well,
Okay. Is a handful?
I apologize. I apologize. Let me correct that. You say the arson unit. I responded partially to your previous question about fire-trained arson members. So between the fire trained and the strictly police officers within the arson unit, again, it would probably be more than a handful, and I'd have to get you those exact numbers.
Okay, but you said, so what about the fire trained, the cross-trained officers? Are they required to wear body cams?
No,
They're not required to wear body cams when they're performing police department duties?
no,
What about the officers that were involved? They are required to wear body cams, right?
strictly Detroit police officers, yes. Investigative units, no. But my understanding is that when executing search warrants, body cameras are utilized.
Okay. Now, is it your information that a total of 2 body cams were provided in this entire investigation by you?
I apologize, sir. Your audio broke up and I didn't hear the question.
Okay. Is it your testimony that a total of 2 body cams were provided by you as a result of the request for this information?
I'm aware of 2 body cameras that were utilized during the search warrants, and I provided, as discovery, the video from those 2 body cameras.
Okay, so it's possible that Sergeant Dave Sanders, is it David or Dave?
David,
Okay, Sergeant David Sanders might have other information as to whether or not other officers have body cams, because he's also, would you describe to be an officer in charge in this matter too?
I would.
Okay,
And to answer the earlier part of the question, it's possible.
okay. So as another aside, Your Honor, I would need to present, and I would ask to be able to voir dire or examine Sergeant David Sanders as it relates to this, because we're not getting the total picture, but I'll leave that there and continue my question.
Okay.
So, I'm sorry, let me go back to my document. And during the course of this investigation, did you investigate cell phone records?
I did not investigate cell phone records from the cell company. We did examine Mr. Keesgan's phone directly.
Okay, so when did you investigate Mr. Keesgan's phone directly?
After he provided it,
Okay, during the course of what he provided, it was during the course of him being arrested, right?
no, he was not arrested. He was detained.
Okay, I'm sorry. While he was detained and not having been provided Miranda is when you got that cell phone from him, right?
We did collect it at that time, yes.
Okay, and as a result of collecting it, then you investigated that cell phone?
That's correct.
Okay, did you investigate that cell phone with a search warrant?
No, he
Okay.
gave consent.
Okay, do you have a written consent form from him?
I do not, but I
Okay.
believe it is on the Warren provided video, and he did provide his passcode for the phone.
Okay, and again, that's why he's handcuffed and being held and detained, right?
That's correct.
All right, so again, that would be another motion similar to the one I made earlier, Your Honor, as an aside. So now, when you went through that particular phone, did you do a phone dump with that phone?
Yes,
Okay, and you did the phone dump shortly after this particular matter was shortly after or within days of that particular arrest?
that's correct.
Okay, and after you have done the phone dump, then you have not done any further investigation about that phone. You got the information that you needed, is that correct?
That's correct.
All right, and so then you went to, hold on. You would agree that the day that he got arrested, he was ultimately taken to the Detroit Detention Center, right?
Yes, he was.
Okay, and when he was taken to the Detroit Detention Center, during the course of an execution of a writ of habeas corpus to garner his release, you had dispatched some officers to go talk to him. Is that correct?
He was interrogated prior to his release, yes.
Okay, and he was interrogated prior to his release, but at the time you recognize, when you go see him, you recognize that an execution of a writ of habeas corpus was in process. Is that correct?
No,
You weren't contacted and told that an execution of a writ was in process?
not prior to his interrogation. No.
Okay. So when you went there, you didn't see, you have to sign in at the Detroit Detention Center, do you not?
We do, and it was not me that went to interrogate him.
Pardon?
We do have to sign in there, and it was not me that went to interrogate him.
Okay, and who was the one who interrogated?
Lieutenant John Davis.
Lieutenant John Davis? Okay, now is he cross-trained? Is he a firefighter or is he a police officer?
He is cross-trained.
Did anybody from commercial auto theft work with you on this?
No, they did not.
Okay, this is strictly a cross-train affair, right?
No,
All right. So now again, you recognize that, okay, you can't answer that question because it wasn't you that went to talk to him. Who else was with Lieutenant John Davis, if you know, when he went to talk to Mr. Keys?
I believe he went on his own.
And did you have any information? You were contacted about a writ of habeas corpus, were you not?
I don't know. I was contacted. I'm trying to remember that evening.
You know what I mean when I say a writ of habeas corpus, right?
No, I don't.
Okay.
I was aware of, no, I can't answer it. I don't know.
You were saying you were aware of something.
I recall that he was released on a writ that, I believe it was that evening or the following morning. That's what I'm aware of.
Okay. So as officer in charge, you would be contacted during the course of the execution of a writ. Is that fair?
I believe so.
Okay. Now, your memory may not serve you correctly today, since we're beyond a year since this happened. Fair enough?
That is fair with this circumstances.
Okay.
The circumstance specifically, for sure.
The arrest was April 9th, correct?
I apologize, sir. I lost your audio there for a minute.
Yeah, it's still unstable. I'm sorry. You would agree that on the date and time of this arrest was April 9th, right?
I believe that's correct, yeah.
Okay. If you get a call, because your memory, I'm using the word if, not as a speculative mechanism, but because you indicated your memory does not serve you correctly. But if you were to receive a call about a writ, they would contact your personal phone or your department issue phone. Is that fair?
That should be my department phone.
Okay. If you were contacted about a writ of habeas corpus, you recognize, based upon your experience as being a lieutenant, being cross-trained, that individual has an attorney in place and has sought relief from the court by way of a writ. Is that fair?
I'm going to say no, and I'm going to share with you my ignorance in writ of habeas corpus.
Okay. So are you aware as to any mechanism by which a writ would be executed?
Your Honor, I'm going to object to this line of questioning. This goes well beyond the motions that were filed.
What?
Object. Well, yes, Mr. Perkins?
Well, my response is the motions that were filed, if I received some of this information in the course of discovery, the things like I have not received the body cams. I have not received these cell phone records, which have been used during
the lieutenant's understanding of the writ of habeas corpus is, I don't think.
Okay, he's right. I'm sorry. Mr. Slusky's right. I got it. I understand what you mean. So But you would agree that if you had knowledge that this individual had an attorney, you would contact, as an officer in charge, you would contact Lieutenant Davis to tell him not to go talk to this individual, would you not? Did you hear that, Mr. Lieutenant Schwedler?
I did, but I was not aware, from my recollection, of any contact with an attorney at the point of that interrogation. So I
Understood, but you indicated your memory. The reason why I'm using the word if is not because I'm trying to be speculative. You've indicated that your memory is not as well served as today as it might have been on April 10th or April 11th of 2020. Is that fair?
It is fair, and I'm going to narrowly accept it for this part right here regarding the interrogation, because I wasn't there. So the time frames, I couldn't even speculate or guess as to what happened at what time relative to that interrogation.
Okay, but you would agree that if you had been contacted by Detroit Police Department during the course of an execution of a writ, it would have been on your cell phone and would be part of your cell phone records. Is that correct?
Objection, Your Honor, asked and answered. We've already been over this.
That's not a question I've asked.
Objection overruled.
Hold on 1 second.
I can't say if it would have been on my department cell phone. They could have also called our office. It's not uncommon for the Detroit Detention Center to call the main number at our investigative office.
Okay, so at the same time, there would be a record. Those phones, and your understanding, those phones have records as far as who calls in and who calls out on department issued phones anyway. Is that fair? Whether it be a landline or a cell phone.
I'm sure there are.
Okay. Now, if you would rely upon what the records say as to when the time is that you received a call, if you received one, is that fair?
Yeah, I wouldn't dispute the records, no.
Okay, so you, upon receiving that call, and if you were alerted, here's where I'm going back to, if you were alerted that there was a lawyer involved representing Mr. Keesgan, you would agree that it's your duty to tell Lieutenant John Davis not to talk to that individual as officer in charge of this case. Is that correct?
I believe I finally understand your question, and yes.
Okay, all right. Thank you. Let me ask you, as it relates to the vehicle in question in this matter, did you return that vehicle to the owner?
No, I did not.
Okay. Was that vehicle ultimately returned to the owner?
My understanding is it was.
Okay. You yourself did not. Do you know who did?
No.
Okay.
The vehicle.
Go ahead. I'm sorry. I didn't mean to cut you off, Lieutenant.
The vehicle was impounded from the location it was recovered from.
Okay. And you would agree that it would be necessary to retain this vehicle for the purposes of continuing the investigation and ultimately the prosecution in this matter. Is that fair?
No.
Okay. You don't think that's fair?
No, I don't.
Okay. Was any inspection made of this particular vehicle at the time of its being picked up?
It was.
Okay. So when this vehicle was picked up, do you know or did you answer this question? I don't know if you did. I'm sorry if you did. Do you know who released that vehicle?
I don't. I don't believe there was a hold put on it. Maybe there was a hold. I think there may have been a hold for Livingston County Sheriff to see if they wanted to look at it. I didn't have a reason to hold it. So I can't say if I released it post the opportunity of Livingston County Sheriff to examine it or not.
Okay. Do you have any records as it relates to whether or not you put a hold on it, released it, or returned it over to Livingston County Sheriff?
I don't, but we could contact the tow company and they could tell us.
Okay. Did you use the tow company?
I don't use the tow company. The
Okay.
Tows are selected in a random manner through the Detroit Police Dispatch.
Understood. What I'm saying is during your function as a law enforcement officer, you contacted someone to tow this vehicle. Is that correct?
I did not.
Okay, who did?
I believe there were 2 officers at the vehicle location recovery. And I know off the top of my head, one of them was police officer on Hofredel. I'm not sure who the other officer was, but I could find it through the activity logs.
Okay. Have you produced the activity logs that have been sought for all the officers?
I have.
Okay. And those would be the officers that are involved not only in Detroit, but Warren, Roseville, Livingston County, and Oakland County?
That's correct. Everything that I have.
Okay, I'm saying, do you have those activity logs for those individuals?
I don't have any activity logs for Livingston County Sheriff. They did not respond or send persons to any of the search warrants for the operations that we did. We only communicated by email and by phone. I did provide activity logs for Warren Police Department and Detroit Police Department. I don't have activity logs for any other agency.
So no activity logs from Oakland County Sheriff?
No. No, as far as I know, they didn't respond to our search warrants. I don't believe.
You executed a search warrant to retrieve this information from Oakland County Sheriff?
Excuse me? Can you please repeat that?
You said that you supplied a search warrant to gather this information from the Oakland County Sheriff?
No, that's not what I said. I said I don't believe any Oakland County Sheriff officers responded during the execution of our search warrant.
Okay, so wouldn't it be a fair statement? Are you not aware that the officers who retrieved this vehicle, that they drove the vehicle back to a location within Detroit?
No, the vehicle was towed. A tow was ordered to the recovery location, and the vehicle was towed from that location.
Okay.
I have no knowledge of our officers or any officers driving that vehicle.
Okay. And have you provided the tow information of that vehicle or in this discovery?
I believe you do have a copy of the tow card, yes. Yep, it is in discovery.
Okay, I didn't know if you were trying to find something.
No, I responded to your question. The tow card was provided in discovery.
Okay, that's the tow card when it goes to the impound lot, right?
Correct.
Okay, but that information does not include who the tow company was that brought that car to the lot, does it?
Yes, it does.
Okay, and it provides the information as to where they retrieved it?
Yes, it does.
Okay.
Is there another question?
And just a couple more questions, sir. You indicated that, can you find out and can you provide whether or not you put a hold on that vehicle? Would there be any information or any mechanism by which we can determine that?
I can contact the tow company. I referred to the tow card in discovery, and there was not a hold placed on that vehicle on the tow card.
Okay.
So it's possible, but I'm not going to speculate that we could have called the tow company to place a hold on it for Livingston County Sheriff. But again, I would have to contact the tow company for that.
Okay, and if ordered to do so, you can do that, correct?
Certainly.
Okay, you remember the tow company that was used in this matter?
What's written on the card is Troy's Towing.
Okay. All right. Just one moment. Who was Cowboy?
Officer Sean Hofer,
Alfred, could you spell the last name?
HOCHRADEL. And it's Sean, SEAN.
Okay. He's one of the officers that was at the facility that recovered that vehicle, correct?
That's correct.
He's the one who referenced you as being chief, is that correct?
I'm not aware of anybody referencing me as chief.
Okay, all right. I don't think I have any additional questions, Your Honor. I do have some requests of the court.
Mr. Selesky?
All right, with that, a period of time ago, an individual sat down in Mr. Kiesgen's chair and he took a picture, and I would like to know who that was and what he was doing taking a picture of this proceeding.
That was, I believe that was Mr. Kiesgen's brother. I can't advise why he took the picture. Maybe didn't know, but that was Mr. Kiesgen's brother.
Could we get an instruction
that
from the
was-
court to have that picture deleted?
Absolutely. I was going to direct him to do so anyway, Your Honor.
Okay, with
Okay.
that, Your Honor, will the court make such an instruction?
With regards to what you just mentioned,
Correct.
I thought I had made myself abundantly clear, but yes, the photo, I think there were two that I heard taken. If they could be, not if they could be, they need to be deleted. Again, I don't want to reiterate what I said earlier. I said it twice, 2 times in a row. And I think I was very straightforward.
Okay, thank you, Your Honor. So I've got a number of issues to address, some of them dating quite a bit back. First, regarding information that was sent to my supervisor, Dennis Doherty. He had received a stipulated order, and when he contacted Mr. Kiesgen to inquire further about that, he did not receive a response, which was why there was no further action on behalf of our office with that. After we responded and didn't receive a response, he had nothing really further to inquire about while waiting for a response from Mr. Perkins. Further, all the activity logs that exist to our knowledge of officers that were involved in responding on the scene have been turned over to the defense. Further, any information about text messages or emails have to be requested by a Freedom of Information request. I would not be the representative for the prosecutor's office to handle that kind of a matter. It would require an attorney from the police department representing the police department. And as I understand, Mr. Perkins already filed a Freedom of Information request for that. And so there's a separate avenue for requesting that kind of information that is already being dealt with. And so that, in a way, is outside of the issues in front of us here today. Further, I'd like to state regarding the recovery of the vehicle, the police were involved in a number of search warrants looking for this vehicle. The police would contend that it would be an inevitable discovery finding that vehicle. If Mr. Perkins wishes to make a motion about I guess, the recovery of that vehicle, I would certainly be happy to respond to a motion in writing. As far as the other novel issues that were brought up by Mr. Perkins, again, if he wants to make a written motion for that, the people would be happy to respond. With regard to every other issue that I believe we've addressed, it either the information doesn't exist or it has been tendered in discovery. And I suppose that's it from the people at this time.
May I, Your Honor?
Yes.
Since we have until I believe October 28th, what I would ask the court to do is to allow me, because I don't believe, I know Mr. Slusky has on 2 occasions has actually come by the office and dropped some things off. So I do appreciate that right in the midst of COVID. I believe one time, and then the other time I think I picked something up. But I don't know, perhaps it's not copied on the disk that I have or the thumb drive that I have or the information I have. I don't have any body cams in the information that I received. So what I would ask, Your Honor, is to allow me to do an index of what I do have, send it to Mr. Slusky, and file it as a reply, because I have a lot more information now. Obviously, there are other motions that I intend to file based upon the information that we received today that I argue should have been part of the discovery, but nonetheless, we have it. And again, Mr. Slusky is right as it relates to the Freedom of Information Act request. We sent them to all these various different departments. But at the same time, this is, to simply say that's somebody else, this is what court is about. Judge, you're empowered to do and order what is, he didn't say that that's not discoverable information. He's saying that I'm not the one that's supposed to do it because that's supposed to be done through Freedom of Information Act. No, if you're gonna charge somebody and I have the right to have that information, this court has an obligation to get that information and order them to produce that information. And they have an obligation to follow that order. So he is correct in that there's a process by which you go through that, but obviously, well, I'm telling you right now, that hasn't worked with the City of Detroit Law Department, which we're gonna sue them about that anyway. But nonetheless, and an entirely separate issue from outside of this particular event. But in this event, he's not saying it's not discoverable. I'm asking for it to be provided as part of discovery. So I'm asking for an order for him to gather that information and to produce that information. Simple as that. It's something that should be done that way. Not that I should go through a civil process in order to get information in which my client is being prosecuted criminally.
Before you prepare that proposed order, please do what you had first indicated you were going to do, which is to create some sort of an index. Because
Absolutely.
we're talking about a non-issue as it relates to the items that Mr. Slusky suggests you are free to
And I'll make this for the record.
Oh, wait, say again?
No, what I was gonna say, and I didn't mean to cut off the court, I'll say this for the record. If Mr. Slusky has it, I believe he's gonna give it to me. Everything I think that he will, but that's not the issue. Is whether or not his witnesses have it is the issue. And now that we have and understand that there's other information that's out there, I'm asking the court to produce it, but I will go through that process and tell Mr. Slusky what's on those discs that he copied for us. And so then he can cross-check to see whether or not I have it or don't have it. And if I do, I can get that. But there are certain things that we know have not been produced. And those are the things that I would ask to be produced by way of records. But I'll put that into writing, Your Honor.
Now, I know that you must have just misspoken. You don't mean that when you say the court to produce, I want the record to be clear, because people who are listening, including your client and other people that may be watching these proceedings, I don't have any information that I'm withholding or that's in one of these drawers that I'm hesitant to tender over. But I do understand your point. It's rather simple. It's very straightforward. If the discovery is there, it needs to be turned over. And when I say there, I don't necessarily mean sitting in Mr. Prosecutor's file cabinet. If the discovery exists, whether in Mr. Slusky's file cabinet or with the officers as it relates to the investigation, it needs to be turned over. For those items, however, for which Mr. Slesky indicates it's more appropriate for there to be a turning over of certain discovery via Freedom of Information Act, there's nothing foreign about that. We'll have to cross that bridge when we get there. I think first things first, that index is a great starting point for which we can make sure that what you're seeking isn't already tendered, or in the event that there's a void, then Mr. Slesky, you need to make a representation that it does exist or doesn't exist, not a representation that you don't have it with a period on the end. There needs to be an indication as to whether or not it exists within the relation to this case. That would include information that you may not have in your possession from the officers. So I think that we're on a good track here. I think we're making some headway. We have the exam date in October, and I anticipate Mr. Perkins is going to be being in contact with Mr. Slesky regarding this index. And in the event that there's not a meeting of the minds, then I'm anticipating Mr. Perkins will be filing not only a motion as it relates to any missing discovery, but also as it relates to the two items that Mr. Perkins put a pin in when he was doing cross-examination of Lieutenant on the record here with regards to the defendant's any statements that were made without Miranda while he was detained and without counsel, and with regards to Sergeant Sanders. So the court is here for whatever you'd like to present, and I would in like manner expect a response in writing from the prosecution in the event that those motions are filed. Again, we've got plenty of time between today's date and October, 28th at 10:30. Anything further today?
No, Your Honor.
Just one thing. So, Mr. Perkins, I did check the evidence that I sent you. I did see body cam included there, so I advise that you do review that since it was already sent.
Okay, I'll look at it.
All right.
Okay,
nothing further from the people.
Thank you for your patience today, and we will see you in October, and I'll look forward to any motions that may be filed.
Great. Thank you. Your Honor, could you put me in a breakout room with Lieutenant Schwedler?
I sure can.
Thank you.
Thank you, everybody. Have a good weekend.
Have a good weekend. Take care.